started. We'll probably have some more people trickling in. We have Brigit Alvarez from LAFLA with us today. She is a senior attorney at the organization, and she is here to talk to us about immigration issues. So, thank you very much.
Thank you.
So Brigit, if you can turn it on.
Oh, yes. Thank you. Is it on now? Okay, wonderful. So thank you everyone for coming, and those of you who are participating via Skype, thank you for devoting an hour of your time to this very important and timely topic, not only for your clients, but for the vast majority of anyone who is interested in applying for lawful status in this era of immigration enforcement. So first of all, we'll get to the basic, and there's probably too much information in the slides, and we won't be able to cover everything today. But just to give you a sense of what's there. We have kind of a spectrum of lawful status, which a lot of people do not necessarily understand. It doesn't go from, someone doesn't go from undocumented to becoming a U.S. citizen. There's a range of statuses, and generally speaking, someone is undocumented, and then from there they can generally, but not always, become lawful permanent residents, and then after having lawful permanent residency for a certain period of time, then they can apply to naturalize and become U.S. citizens. Some common immigration remedies that you might see come up, and I'd like you to be aware of for your clients, are those available under the Violence Against Women Act, which also includes men, but that is the name of the act itself. Immigration Marriage Fraud Act waivers, a U visa, T visa, special immigrant juvenile status, and immigration court. So I'd like you to be able to identify that these are potential issues, but not necessarily assess, be at the level where you can assess whether someone's eligible or not, but just be aware that these could pop up. These are very common reliefs that are available to these folks. So VALA, in a nutshell, is a federal law that allows abused immigrant relatives to self-petition for lawful immigration status. Normally, throughout the Immigration and Nationality Act, you need someone else to petition for you. Not so in VALA. You can rely on your own experience, and in some cases your own credible testimony about what happened to you, without relying on the person who caused you that harm. And the person causing the harm has to have been a lawful permanent, or has to be a lawful permanent resident or U.S. citizen. Some require, or who qualifies, so there's several different relationships. It's not just a marriage-based relationship. The abused spouse of a U.S. citizen or a lawful permanent resident, or the non-abused spouse of a U.S. citizen or lawful permanent resident whose child has been abused, even if it's a stepchild or an adopted child. The abused child of a U.S. citizen or lawful permanent resident, and children of the above, whether they were abused or not. So VAWA really encompasses a broad range of familial relationships, as long as abuse, battery, extreme cruelty is a component of that relationship. Requirements, legal marriage. It was a good faith marriage. It wasn't a marriage entered into for the purposes of obtaining immigration status. Shared residence, battery, and extreme cruelty. That's how we define abuse. And extreme cruelty is meant to encompass all of the other components of domestic violence that are not necessarily physical, so economic, psychological, that type of abuse component as well. So it's either or, it does not have to be both. And good moral character. Good moral character in the sense that the client has not been convicted of certain criminal activities or convictions. Immigration Marriage Fraud Act is really those who have already obtained a condition, what we call conditional permanent residency. So they were married for a short time, less than 2 years, and they apply for immigration status or adjustment of status. They're able to obtain permanent residency, but that permanent residency will expire in 2 years instead of 10 years. Why? Because immigration wants to make sure, or double check, that there is no fraud in the relationship. They want to make sure that the couple is still together. In some cases, so that's why they give a 2-year as opposed to a normal or regular 10-year lawful permanent residency. For those who have a 2-year lawful permanent residency card, and it'll say when it expires, it's critical that they submit an additional petition to show that they're still with the person that they got married to, or the person that they were able to adjust status through. But in cases of battery, extreme cruelty, it's conceivable that that is not always going to happen, that they're no longer going to remain with the abuser or become separated, because again, that becomes another bargaining chip in the relationship that the abuser will sometimes hold over the applicant. So the Immigration Marriage Fraud Act has a component that allows for those who have been subject to battery, extreme cruelty by a U.S. citizen or lawful permanent resident spouse to file that petition for themselves and without relying on the abuser. So who qualifies? Someone who has a 2-year green card and the spouse no longer wants to help out, because that second petition, it's called an I-751, it's normally joint. So normally the spouse and the applicant have to apply together. So unless there's, in cases of battered spouse or good faith marriage, meaning we got married and it was a legitimate bona fide relationship, but now we are formally divorced and it just didn't work out. Or there's extreme hardship. So under either one of those, you can get around having your spouse petition with you to get the 10-year green card. And that's kind of for a small slice of folks. Then U visa, sadly, because we're in a major metropolitan area, you folks have already probably heard about this. This is for victims of violent crime. Not just any crime, only violent crime, and there's for certain crimes that are enumerated under the Immigration and Nationality Act. So who qualifies has to be a crime victim who suffered substantial physical or emotional injury. They must have cooperated with the authorities during the investigation or prosecution of that offense, and they have to receive a certification from law enforcement, so any law enforcement agency that was involved in the investigation or prosecution, showing that they were helpful and cooperative. So these are the actual crimes that come from the Act, and you can see that it's somewhat limited. There's slave trade, which is actually really common in Los Angeles, but it's kind of slow for folks to come forward and discuss that. Fraud and labor contracting, witness tampering. A common one that we see over and over again at the Legal Aid Foundation of Los Angeles, along with other nonprofits, is domestic violence. We see, and any of the iterations that could be formed under or framed as domestic violence. So even attempt, felonious assault is very common as well. So this is just to give you an idea of who or which one of your clients might be eligible if they come forward and actually disclose, like, yes, I was a victim of a crime. You want to ask them of what? So again, the U visa, all of these forms and applications are extremely complicated, and I do not want you to attempt to do these by yourself, out of the goodness of your heart. Immigration is second to, I would say, only tax law in terms of complexity. And there are constantly times when, one of our experienced immigration practitioners will have to correct or fix what another attorney has done, because just the forms are deceptively simple. So if you need advice or anything, feel free to reach out to us at LAFLA for references or to see if we can actually take a case. T visa is again becoming more and more, not becoming common, but more people are coming forward, I think, as they become more aware that the T visa exists and it could potentially help them. LA, as with any other site where there's large immigrant populations, is a hotbed of trafficking. So LA is no different than any other city. Who qualifies for the T visa has to be a victim of a severe form of trafficking. They have to be physically present in the United States on account of that trafficking, and they've complied with reasonable requests of law enforcement, and they have to suffer extreme hardship if they're sent back to their country of origin. So trafficking has very specific definitions under the Act. It has to be sex trafficking or labor trafficking. So purposes, the person has been recruited or transported for the purpose of engaging in a commercial sex act, where the act was induced by force, fraud, or coercion, and labor trafficking in that same vein. So Maria is an example of someone who we helped previously. She came to the U.S. as a child bride from an area in rural Mexico. It was a very common and remains a common cultural practice in this area to marry off recent teenagers, so like 13, 14, to older men. And the husband was severely abusive, he did not allow her to leave the home, and then once she left, he kept their eldest child at the time. So we actually applied for a T visa for her, even though when she came to our organization, she was so traumatized by everything that she had been through. It was really hard for her to tell a coherent story about exactly what had happened. So we had to send her to therapy first, and then when she came back, she told us the story, was able to tell the story, her own story, of how she was married. This is a photo from her wedding, which is a little bit blurry, but you can tell that she's much younger. And she has come out publicly and talked about her town's cultural practice, and actually faced a lot of backlash from her community because she's dared to talk about things that are not discussed or questioned. So yes, now she's here in Los Angeles and very successful. So, and it was because she was able to obtain a T visa. Another case is actually the first recipient of a T visa in the United States. Of course, not the first trafficking survivor, but she was the first recipient of this type of visa. She came from rural Michoacan. She was sold to an older man by someone who was really a broker, someone who promised her a job, and Maria wanted a job, and so she thought this was a great opportunity to help her family. And she ended up being sold to someone who kept her against her will in his home in Azusa, and threatened her to remain quiet by threats of hurting her family. So this, she had eventually ended up going to prison because and this is all in the public record, she ended up going to prison because she was convicted in the 80s for his murder under a conspiracy theory. This was prior to when juries could actually consider and courts could consider information about domestic violence, or what was then called, or I believe what is now called intimate partner battering and its effects. So the jury, even though they were sympathetic to everything that she had been through, they could not legally consider that information in determining or adjudicating her guilt. So what we ultimately had to do was we had to vacate her murder conviction, given that the evidence code had changed, and then she was able to receive a T visa since that conviction was vacated. And now she's a social worker, and she runs support groups for folks who are court mandated to anger management classes. And so it's really, her work is really brilliant. So she's here in Los Angeles as well. So what else you might see, which is becoming more and more common, especially for folks who are recent arrivals, is you'll hear them maybe talk about asylum. And there's really two phases of asylum. There's affirmative asylum and defensive asylum. Affirmative asylum is generally for people who are not seeing an immigration judge. So they've maybe entered the United States with a visa, or entered the United States and were not arrested at the border or arrested at any point. They, within the first year of entry to the United States, they need to file an application administratively, and they'll go to an interview. If they're living in this area, they'll go to an interview in Tustin. It used to be in Anaheim, and the office just moved to Tustin. And this is more or less kind of the process. A lot of people now, since enforcement is at such a high, are actually caught, arrested at the border, and then placed into removal proceedings in an area where they intend to live. So a lot of folks either have relatives in Los Angeles, Texas, Florida, San Francisco area, or New York, maybe Baltimore too. And so if they're able to bond out a custody, then their case will actually get transferred to the immigration court that has jurisdiction over that area. So in the previous administration, we would consider folks as immigration attorneys, we would consider those at risk of going to immigration court if they had something like an open warrant or outstanding orders. If they were transferred from like the sheriffs or from LAPD then they would get transferred to ICE custody. Some denied applications, but not everyone. So maybe a denied adjustment application with criminal history, then yes, that person would probably get referred. But not denied U visas, not denied T visas. In some cases, racial profiling, and then arrests for certain offenses. So domestic violence, child abuse, those most certainly would trigger putting someone into, an applicant into immigration court. Then this memo came out in June of 2018 and basically said the gloves are off. Everyone is subject to enforcement and the rules, maybe the policy from the previous administration is no longer good. So this is the excerpt that I took from that memo so you all could see it. And it just says, have been convicted of any criminal offense, have been charged with any criminal offense, has done anything that could be seen as a criminal offense, just to give you the idea that the wide net that this policy change has cast. So, any admissions, fraud, misrep, and it even says public benefits, although it doesn't exactly say what constitutes abuse. Is it just the receipt of public benefits? Is that an abuse? We don't really know. But what we do see is that the numbers of folks who are placed into removal proceedings has skyrocketed. So much so that we can't even get, the judges can't get the cases done in a timely fashion. So if you suspect that one of your clients has been placed into removal proceedings, you'll generally see a document like this. This is called a notice to appear. This is the first half, and it concerns, you know, factual allegations right here, and then below here they will have a charge. These are the two common charges that we see all the time. One is unlawful entry, another is presence without some type of visa or permit allowing entry. And once you're placed into removal proceedings, then you're actually applying for defensive, what we call defensive asylum. Because you're not applying administratively anymore, you're putting your case before an immigration judge, where there will be a prosecutor and you'll have to present testimony, etc. So who is a refugee? This is where we get the definition of refugee. And a fundamental principle that we cannot return the applicant to some place where their life is threatened. So the post our signing on to the Refugee Act, we largely granted asylum to the majority of refugees fleeing communist bloc countries, and we overwhelmingly denied asylum to 97% of refugees from El Salvador, Guatemala, and Haiti. This was just trends that we saw after the Refugee Act was enacted, and there's the site that gives you a little bit more of the history. So the basic requirements for asylum eligibility, and again, you do not have to be well versed in this to be able to assess one of your clients, but it's a useful framework to keep in mind, because this is something that, you know, someone like myself or any of the immigration attorneys at LAFLA or any of the other immigration attorneys from the Executive Office for Immigration Review list of pro bono legal service providers, we're going to be keeping these benchmarks in mind. So the applicant has a well-founded fear of persecution on account of one of the 5 grounds. So race, religion, national origin, membership in a particular social group or political opinion, or they've experienced past persecution that would give rise to a well-founded fear as well. So persecution. We all kind of know what persecution means generally, but persecution has a very specific definition under the Immigration and Nationality Act. We consider circuit case law, Board of Immigration Appeals decisions, and the United Nations Handbook in determining whether or not someone has suffered persecution. So the harms and abuses have to be considered under the totality of the circumstances. So threats to life or freedom, mental, emotional harm, perhaps substantial economic disadvantage. I recently had a case of a gay Cuban who came to the United States and traveled 8 months to turn himself in at the border and requested asylum. He's 20. He went to a boarding school in Cuba, which our country conditions expert testified was very common for folks who are either openly gay identified or suspected of being gay identified, because it was an easier way to monitor and control their behavior. So Cuba has a history of jailing and imprisoning and torturing its members of the LGBTQ+ community. That has since changed, but nonetheless there's still measures in place that are meant to monitor LGBTQ individuals. So with him, when he was in boarding school, he was burned by students with a hot pot, and he was burned on his arm. and they told him while they were burning him with the kettle that he needed to learn to be a man. Then he was conscripted into the military, as most young men are, and while he was there, he was threatened with rape by a coworker multiple times, and followed by the same coworker every single day on his way home. The coworker knew where he lived, knew who his family was, and when he reported this disparate treatment and this treatment to his the local party contact in his town, the party contact said, look, either you obey the military conscription order or you go to jail. So basically it was telling him, you either deal with this and accept it, or you go to prison. So instead of accepting it, he came to the United States, and he was just recently released. But we had several discussions with the trial attorney, who's the prosecutor, and the judge, trying to convince them that, look, everything that he's been through, everything, all of this treatment, all of this disparate treatment, it's not discrimination, it's actual persecution. Look, here's his scar. We'd request the court take judicial notice of his scar. And he's provided credible testimony. And he's talked about threats of rape by someone who very clearly had the means and the intent to do something about it. So that was a big win for us. So if there's no past persecution, which it seemed like the judge was going to decide initially, you can still qualify if you have a well-founded fear. So if the judge had not found that for us, then we could have tried to convince him that our client had a well-founded fear of return to Cuba. And it's based on a percentage of harm that's likely to occur and what is sufficient. It's a pretty low threshold. It's 10%. So you're showing a 1 in 10 chance that this person would actually be harmed if they were returned. But it has to be subjectively genuine, so the person has to say, I am afraid to go back, and objectively reasonable. And this is the case where that comes from. So nexus, we always have to show that the persecution is on account of one of the 5 protected grounds. So this is an example. Nina says she was raped repeatedly by godmother's boyfriend in El Salvador. Mom left Nina behind with her godmother when migrating to the US. So persecution. Persecution, does rape constitute persecution? Yes, it does. But what's the protected ground? On what basis? Is it race, religion, national origin, membership in a particular social group, or political opinion? In this case, we argued membership in a particular social group because there is a group of children who have been left behind by parents who have migrated to the United States. And so we had to have an expert come in and say, look, there's even a word in Spanish in El Salvador that's in use for those who have been deemed as throwaway children, children who have been left behind. And nexus or motive of the persecutor. In that way, you can talk about things that maybe she remembers, Nina remembers, being told by the persecutor. Sometimes motive can be revealed that way. And again, particular social group, every time an immigration judge hears particular social group, they kind of roll their eyes because they don't want to go down the rabbit hole. They'd like something a little bit easier. And none of you has to be well-versed in this, but just so that you can be aware of the requirements that we're dealing with. If we can't fit it into one of those easier boxes of race, religion, national origin, or political opinion, then we're kind of stuck with particular social group and trying to frame it in a way that would give us help us obtain asylum status. But basically the members share an immutable characteristic that the group cannot or should not be required to change. The group is defined with particularity and it's socially distinct. So, for example, for the Cuban who we just got out of detention, his particular social group is gay Cuban men. For those who are unaccompanied minors, there is an additional, we consider it 2 bites at the apple. So for young people who are coming here by themselves and with no kind of parent or other guardian, they're entitled to 2 filings of an asylum application if they get caught at the border. So under the Trafficking Victims Protection and Reauthorization Act, they're allowed to file administratively, even though they're in immigration court. They get to file with the Tustin office and have an interview, which is a lot less adversarial, a lot less scary for a minor. And then if they can get approved at that office. If they don't get approved, then they get to file their application again before the immigration judge. So it's 2 times that they get to apply if they're an unaccompanied minor. They do not have a 1-year limit in terms of a filing deadline, and USCIS, or the U.S. Citizenship and Immigration Services, the administrative office, has first dibs in adjudicating that case. And actually the adjudication rate, or the approval rate, for those types of asylum cases filed with USCIS first is potentially much higher than the approval rate of that particular judge. The approval rates for asylum cases based by country are publicly available for each immigration judge in the United States. So it's a really helpful tool for those of us as immigration advocates to kind of look up and have a sense of what's my client's shot at getting or obtaining asylum. And these are the requirements for who is an unaccompanied minor. What we're seeing today, so there was a question in the email that I received in terms of what to cover, as what are some trends that we're seeing in immigration right now. We're seeing a lot of these types of push factors, or factors forcing migration. So gangs as really a de facto state, because the government itself can no longer control. They're either not willing or they're unable to control the reach of gangs. There is a lot, let me see. Due to the legacy of Civil War, their violence always trickles down. So violence will always be endemic to families in countries where there's been extensive history of violence. And again, there's an article that provides additional insight into that. Asylum law itself recognizes persecution as gender-based violence, and particular social groups can be framed as gender alone, or we call it gender plus, like some other factor, and claims based on intimate partner violence. But unfortunately, we have seen a lot of movement in this area, and sadly not in a good way. So matter of ARCG is a Board of Immigration Appeals case that came out in 2014. This piece is a local artist, and for more information you can look at his website. But granted asylum to those who belong to a particular social group of married women in Guatemala that are unable to leave the relationship. This woman had attempted several times to leave her husband, and each time she attempted to leave or seek the help of the authorities, she was brutally beaten. And so when she came to the US, she applied for asylum, was denied, and kept getting denied, and then when she appealed, she won. What the former Attorney General Jeff Sessions did in 2018 is he said that generally domestic violence claims by private actors will not qualify for asylum. It did not foreclose these claims, and the legal analysis actually is very confusing, even to those of us who have been practicing immigration law for quite some time. Whether or not he can do this is still being challenged in the courts, and it's unfortunate that when this decision was published, it was widely publicized as, oh, domestic violence is no longer an option. So those of you who are coming to the United States, perhaps fleeing an abusive relationship, you're going to lose. And perhaps that was the intent. Perhaps that was the intent to kind of send this message writ large to folks from Central America who were coming as a part of the surge. But we're still seeing a lot of these claims. They need to be legally, they need to be adjudicated on a case-by-case basis. But it's difficult to convince an immigration judge or an adjudicator that you need to consider case-by-case basis when their boss has told them generally it's not going to fly. So let's discuss, if you see something like a notice to appear or something that looks like a hearing notice and it says immigration court at the top, I provided this, which is the list of pro bono legal service providers. This is for the entire state of California. So it should have been available out front. It's organized by immigration court. So Adelanto Immigration Court, Imperial would be relevant to the San Diego folks who are on Skype. The Los Angeles court, detained and non-detained. Otay Mesa, which is also San Diego, and then San Diego Immigration Court proper. All of these pro bono legal service providers, they've been vetted extensively by the Executive Office for Immigration Review and the Department of Justice. So if you're considering recommending one of your clients or perhaps a family member to one of these organizations, these are the most trusted organizations in the state. Several of them provide low bono services. Many of them, including LAFLA, we provide free legal services. Just someone has to be income eligible in order to qualify. Almost all of them have at the very least Spanish, folks who speak Spanish on staff, and other interpreter services are available. But these are the main folks in the state doing this type of work. There was another question about LA County, and does LA County provide funds for removal defense or for attorneys for those who are in removal proceedings? Yes, they do. It's under the auspices of the LA, what we call the LA Justice Fund, and many of the recipients of the LA Justice Fund grant, including LAFLA, were on this list. So these are the folks who are recommended by the immigration court and also receive funds from the county and the state and the city to defend folks who are at high risk of removal. In terms of whether DCFS has a special immigration unit, yes they do. And they work really well at identifying those young people who might be eligible for something called special immigrant juvenile status. It's highly complex. It either has to be done in probate court or family court, depending on if there's one or no parent here in the United States, and if reunification is not a viable option with one of those parents. The downside to SIGIS is that if a child is granted special immigrant juvenile status, they're not going to be able to petition for a parent. So just keep that in mind. In terms of U visas or T visas, many of these applications you can include family members. It's just, it depends on the type of relief you're going for. So again, make a trusted referral, and then we can assess who else in the family can benefit from something like that. With respect to what access immigration might have to something like a dependency order, we are seeing more and more that immigration, meaning USCIS, ICE, Customs and Border Protection, gets better every year at accessing even more databases. So even though we might consider something safe in terms of a sealed docket or something like that, they might have some other way of getting that information. So what we're seeing now is folks who have a restraining order placed against them due to perhaps one incident of family violence. And maybe it was just a temporary order, and a restraining order after hearing was actually not granted. I have a client who is applying for VALA as an immediate relative of an abusive U.S. citizen wife. She actually placed a restraining order against him, a temporary one. The restraining order after hearing was not granted. And we have faced questions from USCIS saying, well, if you're claiming abuse, how is it that your abuser got a temporary restraining order against you? So this is something, and we assume it's because it was registered with CLES. So this is something that we're seeing more and more often, that USCIS is expanding its reach, and all of the immigration agencies, because there's multiple agencies, right? That they're expanding their reach in terms of access to information. Also, we need to start discussing with our clients their use of social media. Social media is fair game. So this has not happened to me personally, but I have had a colleague whose marriage-based adjustment was going forward in court, seemed like it was no big deal, and then a Facebook profile gets introduced by the prosecutor showing the applicant in a relationship with someone else. So, this could be very problematic, and especially with younger generations, we're seeing more and more folks putting more and more information online. Hashtag no filter. So just keep that in mind. Folks who are applying for something with immigration, we need to be cognizant of what is the public face that they're putting out there. Let's see what other. Let me take this time briefly and ask if there's any questions, because we covered a lot of ground. Can the folks from Skype participate and ask questions as well, or no? I'm not sure.
John would be the person to answer
Gotcha.
that question. I'm not sure.
Okay. Well, how about anyone in the room?
In regards to the, I think it was the U visa
Yes.
that required some sort of crime or act against the person. Oftentimes we have victims of domestic violence. Does it require a conviction in criminal court, or what does it actually require?
That is a great question, because even law enforcement certifiers get confused about this requirement. So let me just quickly skim back to that. There it is. So domestic violence is qualifying criminal activity, but no conviction is actually required. There are many cases where a case, as you probably know, a case could get initiated, but ultimately maybe they get referred to the city attorney, and someone goes to anger management, but charges actually never get filed. The parties agree to keep it, because it's maybe a first-time offense, and maybe the complaining witness no longer really wants to go forward or wants to reconcile, and maybe there's no other criminal history by the alleged perpetrator. There would be no conviction in that case. It would just be a referral for anger management, and as long as that person complied with it, then there would be nothing else. Can the applicant, years later, qualify, or maybe after having left that relationship, qualify for a U visa? Yes. Yes. But can she include the perpetrator? No. So there does not have to be conviction. It just has to be, you have to be a victim of qualifying criminal activity. You have to have been helpful, possess information, and have been helpful, and not unreasonably refused assistance in the investigation. The certification requirement is really critical for U visas. It's so critical that we have annual meetings with LAVLA facilitates something called the LA VAWA network, where we get the big 5 law enforcement agencies in Los Angeles, the sheriffs, LAPD, city attorneys, district attorneys, and DCFS, because DCFS can also certify. Together in a room, and we talk about their policies and what they've done recently, if anything at all, to facilitate the process of signing or adjudicating certifications. And this is always a question that comes up, whether or not there has to be a conviction, even though we've been having these roundtables now for 10 years. And the U visa has been in existence for 20. But it's always good, to get everyone together and have that conversation, make sure we're all on the same page. And even though the U visa has been around for so long, of course you're always going to have changes in staff. So with LAPD, for example, we're seeing a lot of retirements with the folks who are adjudicating the U visa requests. So once new staff comes in, then we see it as a training opportunity to say, hey, this is how we can help. These are the requirements, this is how we can help. Do you have any questions on, indirect victims or bystanders or things like that? All right, what else? Go ahead. Actually, maybe can we pass the mic so that the folks on Skype?
Thank you.
Flip it on, it's probably off.
Oh, okay. Many of our clients that we represent are undocumented, but the children are born here. Is there any special things or provisions we should look for in that?
Yes, especially if there's been an incident of domestic violence and that's how they got into dependency court. Those who are parents of an abused child, and those folks could definitely qualify for U visas as well, as long as law enforcement would certify. So for example, I had a case out of Long Beach many years ago. The daughter had been sexually abused. She was a U.S. citizen, is a U.S. citizen. Sexually abused, and mom cooperated, and as soon as she found out, she provided all of this information, and Long Beach PD certified that she was helpful and she was able to obtain status. But yes, that happens a lot. It's just not, the police or sheriffs don't always know that even though the primary victim is a U.S. citizen, that we can still include a parent or ask for a certification based on the parent as an indirect victim, because harm coming to a child, that type of harm coming to a child is clearly substantial harm.
Thank you.
So,
Thank
yes. What else?
Yeah, I know you didn't discuss this very much, but so say we have clients who are adjudicated and their petitions are sustained. What issues do they face when they're trying to become a legal guardian? LPR or a citizen? Do those proceedings come into play when the moral, I guess it's the good moral character part of their application?
Well, it's not, fortunately, at this point in time, that is not a question on either the adjustment application, so an application for residency, nor an application for citizenship, so to become a U.S. citizen. That could change.
Okay. Just
that could change. We've seen at least 2 revisions of the adjustment application within this administration alone. We've seen 1 change to the naturalization application, and it seems like every day we're dealing with something new. So we'll see. As of right now, for right now.
Nothing.
Yeah.
What changes?
The forms change, and they ask new questions, or they ask the old questions in a different way that makes them a little bit more expansive. So it could be problematic. For example, I had a VALA adjustment applicant who applied, she had her first part of her application was approved, so the VAWA portion was approved, and after that it's like, okay, we should apply for adjustment, meaning green card. She could have filed both at the same time and she chose not to, so I represented her in filing for her green card. When we were at the interview, which took place at the Los Angeles District Office, the officer asked her, oh, what happened when you were a juvenile? And I stopped the interview. Juvenile adjudications are precisely that. They are adjudications of delinquency. They are not convictions beyond a reasonable doubt of criminal activity. So I stopped the officer and said, you know that's off limits. You know that's off limits. So we're not going to answer that. I unfortunately did not know about this juvenile adjudication, and I discussed it with my client after the interview, but best practice was to just shut it down right there. So the officer proceeded gingerly to say a comment to my client saying, look, if you had been a little bit older when you got stopped, then this could have been a really serious offense. And my client looked at her because she was feeling, a little bit scared and in front of an authority, and she really wanted her green card. And so she looks at her and she says, well, and I looked at my client and I said, stop. Stop. This is not a part of your adjudication. It's totally off limits. And again, officer so-and-so, we are not going to answer any questions about this. So then she proceeded to ask her a question out of order about, what was it? It was the gun question. So the question about transporting, have you ever sold, transported, or possessed weapons? And so I knew, because she'd asked this question out of order, that the offense must have had something to do with that. And I told her, again, the answer is, as we specified on the application, and we're only going to confirm that. We're not going to discuss anything that potentially could have happened before my client attained the age of 18. And that's it. My client was just approved. But I know that case was sitting on different supervisors' desks just to make sure that was an okay approval, because we refused to answer questions about a juvenile adjudication. So they are specifically asking about juvenile adjudications, and they've reframed that, they've retooled that question, whereas it used to say on the previous application, have you ever been arrested? Now it says, have you ever been arrested, detained, cited by any law enforcement agency, even if you have been told that it's confidential or sealed or that you do not have to disclose it? Now, under California law, as you probably know, discussion of juvenile adjudications is actually unacceptable. Not only unacceptable, I commit a misdemeanor offense if I do so. So they are highly protected precisely for that reason, to not prejudice the applicant later in no matter what field or area it may come up. So that application invites, imagine an applicant who was just trying to do it themselves. That would have been hugely problematic because at the time that they admit it, it becomes an admission and then it could be used, again, anything you say can and will be used against you is true in immigration as well. So yes, you can see like just with a slight retooling of the language on an application itself, it can create enormous problems for people. So that's a good question. What else?
With the DCFS certification process for the, I believe you said U visa, do you find that they're actually willing to certify? Because one of the things that we encounter in representing domestic violence survivors in court is that DCFS will often say, oh, they've returned to the perpetrator, now they're minimizing, they aren't cooperating with DCFS. And so we run into that a lot in court. So I'm just wondering kind of what's happening on the immigration side of things from DCFS's perspective.
I am not aware of the statistics of approval in terms of signing certifications from DCFS. But from what I remember, so I don't remember the exact number, but from what I remember, on the whole, very positive. DCFS has been a great partner in terms of us providing whatever information we have about the case. They will look through the file to see what level of cooperation has been present and with the investigation, and we'll get a response fairly quickly. It might not always be the response that we want, but at least we're not sitting around for several months trying to wait and see. But they've been a very reliable partner. So. All right, we have time for maybe a couple other questions. Anything else? Okay. All right, well that is pretty much it. I'm gonna leave you with, I believe our contact information is on the website. We have five offices that are here in Los Angeles, and they're all located in areas with the highest index of poverty. So we have an office, let me see. Yes, and we have several other clinics. I want to say around 40 other clinics because I've lost count at this point, that are available in a bunch of different courthouses. So we have, for example, at Stanley Mosque, we have a domestic violence restraining order clinic, which we also do other family law matters if we have no DVROs that are coming in. We have a clinic at the Self-Help Center in Torrance, in the Torrance Courthouse. We're just kind of all over the place. So the best and most recent list of all of our clinics is available on our website, so lafla.org. Okay. Thank you. Thank you.
Time had run out. So I'll take it on.